of your statement, you've set out the powers that the Medical Council has in relation to what I'll refer to as a Section 150 inquiry. Could you please tell the Commission what it is that the Section 150 inquiry involves?
It is an inquiry which is concerned with immediate action against a practitioner, so that if it has been decided that the incident the complaint has been about is serious and may require either suspension or conditions placed on the practitioner's practice, a so-called immediate action Section 150 is organised. That's organised after consultation with delegates of the Medical Council, and then a hearing is made after having notified the practitioner that such a hearing is going to happen. And that under that section, the Section 150 delegates have the power to either suspend or put conditions on the practitioner if justified.
Great. And the term is when the Council is satisfied that such an action is appropriate for the protection of the health or safety of any person or persons.
Yes.
Right. And there was a similar provision in the Medical Practice Act.
Yes.
And you've set out at paragraph 39 that prior to the 1st of August 2008, there was a similar provision, but in slightly different terms.
Yes, that is correct. And as you can see there from my statement, it was when it was necessary to protect the life or physical or mental health of any person, rather than a broader public interest test.
No. And both of the terms within Section 66 of the Medical Practice Act and Section 150 of the National Law, this is a decision for the Council and the Council alone. The Council does not need to consult, for example, or get the consent of the Healthcare Complaints Commission. It can go it alone if you like.
That is correct. But once a Section 150 has determined that action will be taken, that a complaint has to be made to the Healthcare Complaints Commission as a result of that.
Yes, okay. And part of this power here, and this is, correct me if I'm wrong, is it part of that professional expertise that the Medical Council brings to bear, that it has got this power to take urgent action or immediate action, understanding and having regard to the risks to the public or the risks to the patients of the practitioner?
That's correct, yes.
Now, from paragraph 45, Professor, you set out the steps and the steps taken in relation to the complaint of AWG.
Yes.
And you've said that on the 13th of July in 1992, that the Medical Board received a telephone call from a male who was later identified as AWG. Now, and there's a note, a handwritten note, that forms part of the Medical Board and now Medical Council files. That handwritten note you've set out here has said that the male was not sure whether he wanted to proceed with his complaint as he wanted to talk it over with somebody.
That's how I understand it.
Yeah. Now, it's not clear. I mean, do you think that anybody at the Medical Board who took that phone call made an offer to talk it through with this male caller?
I really can't answer that because I'm not sure what would happen in 1992.
Right. But it does seem that this was the end of the story, at least in July 1992, in relation to that caller.
Yes.
Now, at paragraph 46, you've said that the Medical Board referred the male caller to the Complaints Unit, and that was the predecessor for the Healthcare Complaints Commission.
Correct.
Now, the Board had the capacity to receive a complaint itself, though, didn't it?
It did receive that complaint itself, yes.
Well, I mean, it's not recorded here in terms of the medical board's, in terms of the medical board's records as a complaint.
I am not certain as to the law in 1992 as to the requirements of the medical council versus the the complaints unit at the time, and what the procedure was then. It was well before my time. I'm afraid I don't know the answer to that.
Mm-hmm. Okay. But it would seem here that from the terms of what you've set out at paragraph 46, that the caller was told that the place to make a complaint was the complaints unit.
That's right, yes.
Right. Is it possible to have section 42 of the Medical Practice Act put on the screen, thanks? It's the version of the Medical Practice Act that was in force in 1992. I think it's in the legislation folder. Tab 17. There you can see, Professor, that at section 42, the Act, and this was in force at the time, that complaints are to be made to the board. So certainly the board had the power to receive complaints. And in fact, what's happening, what's been recorded in terms of the note in relation to AWG is that the male caller is being told to go elsewhere.
To the complaints unit.
That's right. Now, at paragraph 48, there is a record of another phone call on the 18th of September 1992 to the medical board, again wanting to make a complaint against Dr. Rolleston, and Dr. Rolleston here is named, on the basis that when he was 14 he saw Dr. Rolleston for a sore throat, and that Dr. Rolleston first asked for a semen sample and secondly manually assisted Mr. AWG to obtain it. Now, at this point, there's quite a bit of detail in relation to what's troubling this male caller, isn't there?
Yes.
And the last part of that paragraph is that Mr. AWG also wanted to know if Dr. Rolleston is still registered.
Mm-hmm.
So it's certainly alerting the medical board at that point in time that there may be live issues in terms of this practitioner and the safety of this practitioner in relation to current patients.
From what I understand, the person who received the complaint told the complainant that Dr. Rolleston was conditionally registered, so clearly the board was aware of that, and the conditional registration, as I understand it, was the result of what was brought up earlier about his Medifraud, etc. issues.
Yes, Doctor, you've set out at paragraph 50 there that Mr. AWG was advised to put his complaint in writing and that Dr. Rolleston was conditionally registered. So certainly at that point the medical board understood that he was conditionally registered.
Yes.
And as you say, the conditions related to the Medifraud and related in terms of sort of financial issues rather than anything else. It's certainly no comfort to the medical board at the time that these conditions were imposed upon that practitioner when in fact what's being complained about is the fact that he sexually assaulted a 14-year-old child.
Mm-hmm. Is it a question or?
Well, it's a question, yes. It was actually a proposition, I apologise. But I will put a question to you. Was it reasonable for the board to be comforted by the fact that there were conditions placed upon this practitioner's registration when the conditions related to financial issues and the nature of the complaint related to a sexual assault.
Yeah. As I understand it, the response was that he needed to put his complaint in writing, which was the legislation at the time, as we saw just a minute ago when you put the Act up, and that's what he was advised to do. The fact that he was conditionally registered because of his financial problems would have been thought at the time, and I'm only speculating here, as to be a separate issue. But as was pointed out earlier this morning, it certainly may have been seen, or should have been seen, as an indication that Dr. Rolleston was not an honest, straightforward medical practitioner.
Now, Doctor, at this point in time, we've got the 18th of September 1992. There are records with the medical board that there is a practitioner out there still practicing. There are concerns by somebody out there in the public that we're referring to as a male caller currently, reporting a sexual assault on a 14-year-old and raising the issue, worrying whether he's currently practicing. Now, from what I can see here is this male caller was told to go and put his complaint in writing, and this note was filed in a drawer or somewhere.
Somewhere, yes.
Is that a satisfactory response on the part of the medical board?
In hindsight, probably not. I think that one has to understand the way things might have been thought of in those days. Certainly, if it were now, it would not be satisfactory. The legislation would probably have played a part in the thought processes of the people who were involved then, and being that the complaint had to be in writing and a statutory declaration had to be made, which somewhat hamstrung people. But as I said, if that were today, I think a different approach, I know a different approach would have been made.
Right. And today, in terms of the assistance, is it the case that there's more capacity for the board or now council to offer assistance to any callers in relation to going about putting any complaint in writing?
Yes, because one of the things that's happened since about the year 2000 is that we now have a medical director who is very much attuned to the nature of serious complaints. And as that happened now, as I mentioned earlier this morning, the medical director would have been instantly involved in that, and I have no doubt that the medical director, who would be from that year, would have taken that complaint much further.
Now, you also give an account of the dealings of the medical board in relation to the complaint by AWC. Professor, I might take you to paragraph 57 of your statement, and you've stated there that on the 19th of October 2001, the medical board received a letter from the Healthcare Complaints Commission dated the 5th of October 2001 as a consult as to whether the matter was to be terminated, and enclosing a copy of their investigation report. Now, this is the initial complaint that started out in 1998 and had been around in the system for a while. Now, this is actually a complaint that you personally were involved in, And you've said at paragraph 58 here, on the 9th of October, I wrote to the HCCC disagreeing with the HCCC view that the matter should be terminated. And then you later set out that there was a meeting to be set up by the subcommittee. Now, how does this type of thing happen when it occurs? This is the consultation process that must occur between the Healthcare Complaints Commission and the Medical Board.
The system was slightly different in those days, in that we had a subcommittee of the Conduct Committee, but the initial, and we did not have well, we did have a medical director, I'm sorry. One of the delegates or the chair of the Conduct Committee was the initial point of conduct of the consultation between the Commissioner of the Healthcare Complaints Commission and the Board. And I was that person at the time as chair of the Conduct Committee. And as you can see, and there's a handwritten note that I made disagreeing with their with the Commission's decision to proceed no further. And that needed to be discussed further at a committee level, which was done.
Right.
And as I recall, and this is purely from memory, in those days the commissioner, who wasn't the present commissioner, or the commissioner's delegate, it wasn't always the commissioner, or the commissioner's delegate, used to attend those meetings. We stopped doing that, I'm thinking about 2008, but at those meetings, the commissioner or their delegate would attend the meeting. And hence there was a lot of discussion, and I can't recall the exact discussion, being some time ago, but it was decided that the Commission had powerful arguments as to why this case wouldn't succeed or not, and I think the Conduct Committee reluctantly agreed that they had no choice but to agree with the Commission's decision.
Okay. You also make the comment in paragraph 58 that at the time you weren't aware, and the committee weren't aware of the note in relation to Mr. AWG. At that point in time, and this is 2001, there wasn't any electronic sort of monitoring system being able to track respondents or complaints or anything like that.
Probably not.
Right. Now, later on in the page, down in paragraph 63, you note that in 2006, so on the 10th of October 2006, the Medical Board's Conduct Subcommittee met in relation to whether a complaint by Mr. AWH, and you note that a similar but separate complaint against Dr. Rolleston should be terminated as recommended by the HCCC. Now, I think it's at this point that the connection between those two complaints was made.
Yes.
Yeah. Now, that was in October 2006. Across the page at paragraph 78, you've said, on the 23rd of November 2006, the Medical Board wrote to the HCCC submitting a complaint about Dr. Rolleston based on Mr. AWC's original complaint and recommending a thorough investigation be undertaken by the HCCC.
I'm sorry, Dr. Bennett, I'm not sure I've got the right paragraph there.
Sorry, paragraph 73. 73,
I thought you said 78, I'm sorry.
I probably did, I'm sorry, I'm sure it was me. So, paragraph 73.
Yes. Could you repeat it?
And just the first part of it, on the 23rd of November 2006, the Medical Board wrote to the HCCC submitting a complaint about Dr. Rolleston based on Mr. AWC, his original complaint, and recommending a thorough investigation be undertaken.
Yes.
Now, could I ask for the document behind tab 112 to be put on the screen, please. Now, this is that letter dated the 23rd of November 2006, and it's a letter to Mr. Pem. And could I please ask you to scroll down to the third paragraph of that letter? Just to orient you, I would stop at the second paragraph there. The committee noted that an investigation into Mr. AWC's complaint made in 1998 was terminated, etc. So it lays out the background. And there at paragraph 3 it says, in considering this matter, the committee also noted that there have been 2 separate complaints of a similar nature alleging serious professional misconduct by Dr. Rolleston, and this is the complaint in relation to AWH. And of course there's his brother there too, AWO, and Mr. AWC. And this is where the committee views these allegations with great concern, which warrant a thorough investigation. Now, underneath that, the paragraph says, the board complains that Dr. Rolleston may be guilty of unsatisfactory professional conduct and or professional misconduct and is not of good character. So in framing the complaint in relation to that it may be guilty of professional misconduct, in the board's mind at that point, the board was considering that the conduct of Dr. Rolleston was of sufficient seriousness that it could justify cancellation or suspension of his registration.
Yes, because the term professional misconduct is one that justifies suspension or cancellation of registration.
That's right. And what about is not of good character? Can you tell the Commission what was underpinning that particular aspect of the complaint?
I would think it's a combination of his the late 1980s Medi-fraud plus these allegations of sexual misconduct.
That's right. So at this point there are numerous examples of people who have been subject alleging serious criminal conduct in relation to Dr. Rolleston, and the board certainly has its own serious worries about Dr. Rolleston, and the board is aware that Dr. Rolleston is still working currently, and this is 2006. So at this point in time, he's got an unencumbered registration. He's not got any conditions on him. Why at this point isn't the medical board recruiting its powers under Section 66 of the Medical Practice Act?
I think that is the big mistake that the medical board had made with some of these cases, that we didn't exert our powers for a Section 66 in those days soon enough. And certainly with hindsight, I think that should have been done, because he, as you say, he was still practicing, and it therefore would be possible that he was still engaging in this behaviour with other young people. Now, although we have no evidence that that in fact occurred, it may well have occurred, and there certainly was a more than slight possibility that it could have occurred, and I think that should have been enough to warrant a Section 66 inquiry.
And Professor, you just said just a little earlier on, there was some suggestion in what you said that there's a greater awareness on the part of the Medical Council now of its powers within the current Section 150 and the old Section 66, that the Council does have those powers and they really need to act on them in the appropriate circumstances.
I think there's always been an awareness of the powers, but I think that the ability and the thoughts of being able to act on them is now much firmer in the conscience of the Medical Council, because, as I said, I would have no doubt that if this happened today, that a Section 150 hearing would have occurred very promptly.
Okay. Over the page at paragraphs 79 and 81, it's at paragraph 79, you say that on the 2nd of April 2008, the Medical Council received from the HCCC a fax letter confirming that their investigation into the complaint and related complaints of Mr AWH and his brother had been finalised, and that the HCCC had recommended for the matters to be referred to the Director of Proceedings there. Now, I mean, I guess you'll have regard to the fact that this is 2 years down the track in terms of how long it takes for these investigations and decisions to be made. And you'd agree, and this is just taking up what you've already said, the need of medical boards to be mindful of the fact that on the one hand you've got the Healthcare Complaints Commission that are doing things in the way that they do things, but in fact it's the medical board that has the power to do things immediately and act very quickly.
Yes. And I think one of the important things there is a communication issue between the Complaints Commission and the board at the time, in that we certainly had lists of areas that were being investigated, and from time to time we would look at those lists and say, what's happening with such and such a case, what's happening with such and such a case. But I think that an improvement would be for a better communication about the serious cases like this, so that what would happen is it'd go into the investigation phase, and apart from those lists, we wouldn't know where the investigation was up to usually unless we actually asked the Commissioner. And it would be helpful, and this has not been formalised at all, but I think it would be helpful if cases that went on for after a specified period of time, there was formal discussion about the progress of the investigation, what was happening, to bring the board's and now the council's attention to remind them of this sort of thing, so that if necessary during the investigation phase, a Section 150 inquiry could be held. And that happens to a certain extent, but it would probably be an improvement on, and this is not a criticism of the Commission at all, it would probably be an improvement if that sort of thing happened.
Right. So, Professor, you're saying that's not happened just yet, but it's something that you're mindful of and you would like to take forward and see some sort of resolution and clarification of. At paragraph 81 of your statement, you've said that on the 8th of April 2008, the Medical Board's Conduct Committee met and resolved that the Medical Board concurred with the HCCC's recommendation for the matters to be referred to the DP, and that the Medical Board considered the appropriate forum to hear the matters was the Medical Tribunal, and that the possibility of a Section 66 action under the MPA should be discussed with the Healthcare Complaints Commission at the next meeting, and so on. Now, I'll just ask for that, the document behind tab 182 to be put on the screen, please. Now, Professor, these are the minutes from the meeting that I think you're referring to in that particular paragraph. You see at the top there, the 8th of April.
Yes.
Now, could we please scroll to the second page of that document and halfway down that page to where there's a heading discussion? Now, there you've said the committee discussed at length the possibility of action pursuant to Section 66. So again, you've said before that it was unfortunate that the possibility of a Section 66 inquiry didn't happen at least 2 years earlier, but at least it was discussed here in 2008. Now, at the meeting, you've listed a number of issues that were raised in relation to the Section 66, the possibility of Section 66 inquiry. Now, if you go down to the number 3 there, it said the committee resolved to discuss the possibility of action pursuant to Section 66 with the Commission at the consult meeting on the 22nd of April. Now, there's no requirement for the medical board to consult with the HCCC at all, is there?
No.
I mean, there's nothing to stop it, certainly, but there's absolutely nothing. It doesn't need the HCCC's consent at all. It uses its own professional knowledge and expertise to make that judgment call. Mm. Now, after that...
But can I make a comment about that? It would have been helpful, however, to make that judgment call, to have that extra information that was there. Mm-hmm. Now, certainly, the board could have done a Section 66 then on the information available to it, but it would, if the Commission had the sort of material that is listed there, it would strengthen the case for a Section 66 inquiry to be held and for the inquiry to have as much information as possible to make a decision.
Mm-hmm. Well, let's just have a look at the information the Medical Board was seeking, Professor. It says here the Commission may be in possession of material corroborative of the complaints, such as medical records from Royal North Shore Hospital or medical records from St Ives that would assist the committee in deciding if action under Section 66 is warranted.
Yes.
Now, Professor, how is it that that information could assist the medical board in deciding whether it was now appropriate to conduct a Section 66 inquiry in relation to Dr. Rolleston? Surely the relevant information would be, where is this person practicing now? Does this person have access to children now? Isn't it the case that the driving factors as to whether an inquiry ought to be carried out now are contemporaneous issues?
I agree, except as I said before, the extra information would have assisted that if that extra information had been available quickly and if a Section 66 inquiry had been held, which it wasn't, then that would have been extra information valuable to the delegates deciding whether it should happen or not, and particularly to the Section 66 inquiry at all. And that would depend on the amount of time that could happen in. And I would expect from reading that back in 2008, one would have hoped to get that information from the Commission very quickly, and so that the action then could be taken.
But Professor, just looking at the terms of exactly what you were seeking from the Healthcare Complaints Commission, could you explain to the Commission how it is that that information was going to assist the medical board to determine whether an urgent inquiry needed to occur or not?
I think it would be extra information that would help.
Now, that was the minutes from the meeting which took place on the 8th of April 2008. Now, at paragraph 85 of your statement, you've indicated that, in fact, the medical board was still waiting on that information from the Healthcare Complaints Commission. And in your last sentence there at paragraph 85, you've said that you were yet to receive it.
Yes.
That's right. Now, if you go down to paragraph 87 there, it says, on the 27th of May 2009, the medical board wrote to its delegates for a consultation as to whether Section 66 proceedings should be convened based on a complaint by Mr AWB. So that's a new complaint in the system.
Mm-hmm.
A related but separate complaint against Dr Rolleston and other previous complaints, including the complaint by Mr AWC. Now, Professor, this is 1 year later.
Yes.
So a year's gone by, the medical board's still waiting from these documents from the HCCC that have never eventuated. The medical board has in its mind, are we going to conduct this urgent inquiry? And a year's gone by. Can you explain?
Completely unacceptable, I agree. Somehow, I cannot explain it, somehow that got overlooked. And as I said earlier, my regret is that a Section 66 action had not been taken much sooner.
Now, I mean, I've asked you before, Professor, about any sort of electronic monitoring systems available to the medical board and now medical council. I mean, initially when I was asking those questions, I was talking about 1992,
yes.
When the first handwritten notation was there. But, Professor, we're talking about 2009 now, so it's actually fairly recent.
Yes.
Are you not able to, is there no electronic system, even as recently as 5 years ago, that tracks and monitors this type of complaint in particular, where there are urgent issues involved?
I don't have a definite answer to that question. I don't think that there is a tracking system that can do that. There should be. And as I would say that if a Section 66 or now 150 is contemplated, it should be there, up there in front, electronically and with some responsible officer, to be sure that it is carried through. And I do not know why that didn't happen, but as I've said before, it should have happened.
Now, at paragraph 91, in fact, the board did, on the 23rd of June 2009, conduct that inquiry, and it was at that point that conditions were put on the conditions were applied that Dr Rolleston had to comply with. Now, those conditions related to the fact that he was not to provide medical services to any patient between 11 and 18 years of age, and that chaperone conditions applied to all patients aged between 0 and 10 years.
Yes.
Now, in terms of compliance with conditions, is it the case that there's a lot of responsibility on the respondent themselves to make an undertaking and to be responsible, to be compliant with those conditions?
Yes, there is.
Okay. And again, Dr Rolleston was remotely located in Broken Hill. And does that mean that compliance, or monitoring anyway of compliance of conditions, is that little bit harder?
A little bit harder, yes. But you still would have had to produce the chaperone logs on a regular basis. And in relation to that obligation of having to
to provide the logs, a lot of that is dependent upon the honesty and integrity of the respondent, isn't it?
As well as the chaperones themselves.
Yes.
Because, as I said earlier, it needs to be signed by both parties.
Mm-hmm. At paragraph 94, you set out the participation of the medical board in the processing of the complaint by AWH. Now, again, at paragraph 98, on the 17th of June 2003, the HCCC and the medical board consulted and determined to refer AWH's complaint for investigation. Now, at this point, again, there was no link made between AWH and the 1998 complaint, was there? At paragraph 103, you've said, on the 9th of December 2003, the Medical Board's Conduct Subcommittee met and resolved for an investigation to be discontinued and for the HCCC to make at least one more attempt to obtain further particulars and a statutory declaration for Mr AWH. Now, can I ask for that document, which is behind tab 72, to be on the screen? And then you can see at the top left-hand corner there, Professor, that this is the minutes from the 9th of December 2003. And if you just scroll down about a little over halfway, there's a heading discussion. Yes, you can stop there. It says, the committee noted its concern at the serious nature of the allegations against Dr Rolleston and that there was a previous complaint against Dr Rolleston of a similar nature. So certainly at that point in time, the connection had been made with the earlier complaint. So there's an awareness, there's the earlier complaint and this one as well. The committee noted that despite a number of attempts by the Commission, a statutory declaration had not been obtained and thus had no alternative but to agree to the Commission's recommendation of the discontinuous. But, Professor, there were other alternatives, weren't there? I mean, in terms of the Healthcare Complaints Commission itself, there were alternatives in terms of encouraging the respondent to go to the police themselves. I mean, this is where the whole issue of police could be raised. There is a serious allegation that both the Medical Board and the Healthcare Complaints Commission know about. It's of serious criminal conduct to more than one person, and yet there's a roadblock here because there's a statutory declaration that isn't forthcoming. It's just not enough, is it, to say there's no alternative and to let these complainants down in a sense, and in fact the public down, who, given that this practitioner is still seeing patients and still seeing children?
I think that, although I agree with the tenor of what you're saying, I think that the no alternative mention was no alternative as far as pursuing the complaint through the healthcare complaint system. That as there's no statutory declaration, which was required by law then, that the Commission could not do anything further from the point of view of referring it to a further investigation or tribunal because of the law about the statutory declaration. So that no alternative refers to that. But I agree with you. There are other alternatives, such as referring to the police, which was not done either by the Commission or the Board at the time.
Yes. in relation to this consultation process, even though part of the consultation process, and you've certainly done this earlier and you referred to it, for instance, you make a recommendation that the Healthcare Complaints Commission have one more try to get a statutory declaration, yes. For instance, that recommendation can be made. Now, at the end of the assessment phase, that the Healthcare Complaints Commission carries out, it can make a referral to the police. So, yes. So there are certain powers that the Healthcare Complaints Commission has in relation to that. Given the expertise of the medical board, having that specialist professional knowledge in terms of risks and vulnerabilities that relate to the relationship of a medical practitioner with patients, it was certainly one of the alternatives that the medical board could have made at the time to the Healthcare Complaints Commission, drawing attention to those sort of vulnerabilities and risks.
Yes.
Now, turning to paragraph 155 of your statement, Professor.
165?
I think I said 155.
No, I just didn't hear. I just didn't hear. That's why I questioned. 155. Yes.
Yeah. Now, you said here on the 7th of July 2009, the Medical Council was notified of criminal charges against Dr. Rolleston. And yes. At paragraph 156, on the 22nd of September 2009, complaints by 9 people against Dr. Rolleston were referred for investigation by the HCCC. And then at paragraph 157, at the Medical Board's Conduct Committee meeting on the 13th of October, there was consideration given as to whether the conditions imposed upon Dr. Rolleston's practice provided sufficient protection in the light of the further complaints which related to teenage males in the 1970s. Now, it was resolved at that point, on the basis of the information before the Conduct Committee, that the conditions provided sufficient protection to the public. Now, again, looking back on that decision right now, at that point in time, there was Dr. Rolleston, who was working in Broken Hill as a medical practitioner. He did have some conditions on his registration, but the allegations against the doctor were serious criminal allegations. There were many of them. I mean, we've got 9 people at this point here. Now, this is in the context of a practitioner who'd been deregistered before in about 1987 for dishonesty offences. And he's in a location where he's got these conditions, but there is some level of difficulty in terms of monitoring him. And I'm suggesting to you that at this point of time, there ought to have been greater unease about the fact that these conditions did indeed provide sufficient protection to the public.
I think it's a matter of, at that time, it had to be a matter of judgment by the Section 150 delegates as to what conditions they put on versus suspension. The view at the time, and this was before the 2010 National Registration and Medical Practice Act being repealed, the view at the time was, rightly or wrongly, that one should put it on conditions which would protect the public, but not maximum conditions. So the phrase was used, and this is not a good phrase, I would agree, the minimum amount of protection that, the minimum amount of conditions that would enable protection of the public. And obviously the delegates who were experienced people from the medical board thought that those conditions of chaperone, which are common conditions put on doctors with sexual offences, and restriction on the patients that they could be seen would have been sufficient to protect the public. And if those conditions were complied with, and I take your point about his honesty, if those conditions were complied with, then the public would have been protected, because he would have had to have a chaperone and not being able to see patients at all, depending on their age group. In the event, it turned out that the conditions weren't complied with, and hence, as I'm sure you're about to ask me, he was in fact suspended.
Yes. When I took you there at paragraph 157 to the Conduct Committee on the 13th of October 2009, Professor, you see what we've got is the July decision. We've got the July decision, and at paragraph 156, on the 22nd of September 2009, there were the complaints about 9 people. So at this meeting in October 2009, there is just more information available, you see. What I'm suggesting is there was a decision made to put conditions upon Dr. Rolliston's registration, and then more information became available. And what I'm thinking is happening at that committee meeting on the 13th of October is you've got the decision from the original Section 66 inquiry. Things have happened downstream from that, so new information's become available, and that new information is discussed at that October 2009 meeting. So I'm suggesting it perhaps was a line ball decision for the original Section 166 inquiry, and I'm wondering whether now looking back you're thinking then, well, rather than wait until this practitioner starts breaching the conditions, as there's probably a suggestion in his background he might do, now is the time to conduct another Section 66 inquiry, because I'd imagine that was the point, wasn't it, of that 13 October meeting?
Yes, and that certainly would have been discussed in a lot of detail. And as I said earlier, obviously the conclusion that the committee came to, rightly or wrongly, was that the conditions were sufficient to protect the public in Broken Hill. I suspect that although the Conduct Committee would have known about the 1980 Medifraud business, it was really overshadowed by these events, and not sufficient attention was paid to the fact that Rolliston was in fact a dishonest person, which would then lead to a reasonable conclusion, as you have suggested, that he might be dishonest in complying with these conditions. And as it turned out, that was the case.
So yes, I won't take you through it, Professor. Across the page just is the doctor did breach those conditions, and as we know, on the 25th of March 2010, there was another Section 66 inquiry which is resulted in the suspension of his registration.
Yes.
Yeah. Now, Doctor, at the end of your statement from from paragraph 172, you refer to the relevant policies, or you address the issue of relevant policies, and you've said there that the Medical Council doesn't have a policy which is directed to dealing with handling of complaints of child sexual abuse. So did you just want to say something generally in terms of how it is that the Medical Council now might deal with these sorts of issues?
In the way I outlined this morning, if a serious complaint comes in, whether it be, and certainly it's clear that the consciousness of child sexual abuse, not only because of this Royal Commission and events surrounding it, has been raised in the public awareness more. And even though we abhor that sort of conduct by doctors, it's now come to, obviously, to our level of consciousness that such conduct, unfortunately, very occasionally does occur. So that although we don't have specific procedures for child sexual abuse, certainly we have procedures which, when something of a serious nature comes in, and a more common situation in this area would be a sexual abuse problem in adults by medical practitioners, which is again rare but much more common than what we're talking about now. We would escalate it quickly.
Professor, do you have any idea of what percentage of complaints go to the Medical Council as opposed to directly to the Healthcare Complaints Commission?
20%.
20%, okay. And in terms of the people who answer the phone or deal with the emails, have they got a general sort of training in terms of complaints handling?
Sorry, I missed
training in terms of complaints handling.
They do have a general training, and one of the things we have discussed in recent times is whether that training is enough. And as you can see from the annexures, there is a complaints handling manual that we have. But I think, and this is the basis of some of these discussions in recent times, is that the training should be, in fact, improved and increased so that they get the best possible outcome. And that, I hope, will happen.
Now, Professor, you're aware of the mandatory notification by health practitioners provisions in the national law.
Yes.
And before that, within the Medical Practice Act, there was a similar type of mandatory notification provision there, which related to medical practitioners about medical practitioners.
Yes, we in fact, I think the first jurisdiction to have that inserted into the law.
Right. And does the Medical Council have a role in terms of educating medical practitioners about their obligations under the national law?
We have a role, yes, because part of the national law is specific to New South Wales, but that doesn't apply to mandatory notifications. That's part of the national law for all jurisdictions. And from time to time we have made practitioners aware of that, and there's been, in the medical press particularly, there's been quite a lot of discussion about mandatory notifications. And as well as that, and this doesn't directly answer your question, I know, but as well as that, the Medical Board of Australia also puts out a newsletter and have from time to time talked about mandatory notifications. And I think the general awareness of mandatory notifications through the profession has now become fairly high. I think that doctors are generally aware of their need to make mandatory notifications. They're not quite as aware as to the exact circumstances that they make mandatory notifications, because I think that some so-called mandatory notifications don't fit the criteria, but that's okay, because it's better to have a notification that's not necessarily mandatory rather than have no notification at all. So I think that largely any error in mandatory notifications is that doctors will make a notification that's not necessarily mandatory, if you understand what I mean.
Yes.
But I mean, with 27 or 28,000 doctors in New South Wales, it's difficult to get out to all of them because they have to read the material that's sent to them, they have to digest it, etc. And the level of compliance with reading these sort of things is not 100%. And other organisations such as the AMA and the College of General Practice and the other Royal Colleges also put out to practitioners information from time to time about this. So I think a lot has been done to try and educate doctors about it. And what I'm not certain about is how much the medical schools educate their students about it. We try and get to the medical schools by giving lectures there, and I've given lectures to University of Newcastle, and our medical director gives similar lectures where we talk about these sorts of things. But of course there's a lag time between those students becoming doctors and getting to the more established part of the profession is not quite as easy as it might seem.
In addition to a doctor's mandatory notification obligations under the national law, doctors also have mandatory reporting obligations under the Children and Young Persons Care and Protection Act.
Yes.
Now, you're familiar with those provisions, aren't you, Professor? Now, under those provisions, the medical practitioner, there is a duty to report, for the person to report as soon as practicable to the Director General. Now, that's not obviously to the Medical Council or to the HCCC, that's to the Department of Family and Community Services, so it's a different person to report to.
Yes.
But they must make that report, and the name or a description of the child, and so this relates specifically to children, and the grounds for suspecting that the child is at risk of significant harm.
Yes.
Now, what the current Act has also is that it says a person to whom this section applies satisfies his or her obligations under subsection 2, and that's that bit I've just read out to you in relation to identifying the child that is at risk. In relation to 2 or more children that constitute a particular class of children, if the person reports the class of children to the director. So are you aware that, for example, a doctor under this legislation can have serious concerns about a class of children that is at risk as opposed to a single child?
I understand what you're saying, yes.
So what I want to take you to is this. In terms of if this were to have been in place at the time of Dr. Rolleston, for instance, and an adult reported to a medical practitioner that they were abused when they were a child, and that the person is an adult now, so in a sense that person no longer comes within this particular Act, but the medical practitioner that has had this reported to them is aware that alleged perpetrator is still a medical practitioner and is still working with children and treating and seeing children. Professor, would you accept that, or would you expect that a medical practitioner would then be concerned under this Act that there is a class of children at risk.
Well, Your Honour, I have to object to that, really on the grounds that it's unfair in two respects. With great respect to the counsel assisting, the question does wander over a number of concepts. And secondly, it's ultimately asking the witness to express what must ultimately be a legal opinion. And in that sense, Your Honour, it won't help the Commission. It's a matter about which certainly submissions could be made, but whatever answer is obtained from this witness couldn't be of assistance.
Well, I think we'll see what the answer is, Mr. McCulloch. We can work it out from there. Yes.
If I can paraphrase your question to make sure I understand it correctly, an adult comes to a doctor and says that he has been sexually abused as a child. Does that doctor have a obligation to report to the Family and Community Services under the Child Protection Act, despite the fact that he is no longer a child? And it's not a child but it's a class of children. And not knowing the Act in detail, I don't know whether the Act applies to that sort of situation. If I, in my completely non-legal way, had to make a comment about it, I would say that it's likely that the Act hasn't specified that, and that the knowledge that this might apply to this class of children, even though the person who's made the admission is now an adult, should be reported. However, I would expect that the vast majority of doctors would not know that.
Thank you, Professor. Professor, in the course of these proceedings, a number of the former patients of Dr. Rolleston have given evidence of their experiences of the childhood sexual abuse, and they've also given their experiences of trying to report it to various professionals, the medical board and the HCCC along the way. Have you been provided or with the statement or been told of the evidence that AWA gave in relation to his attempts to report his childhood sexual abuse to the medical board?
Unfortunately, the initialisms
Yes.
are a little bit difficult for me to remember. Is AWA, or is the... No, I've got that. Are you referring to the complaint that was made initially to, or leads to be made initially to the medical board in 1977?
Yes, and I'll just ask that that statement be put on the screen. It's behind tab 1, and it's at, say, paragraph 22, starting at 21, and then going, if you could scroll down to paragraph 23 and...
Yep.
Professor,
Yes.
I'm just going to give you an opportunity to perhaps read what it is that AWA said occurred. This is a telephone call he says was made to the medical board in 1977. And just to give you the opportunity to make a comment about that.
I think it is highly unlikely that a medical board employee, even in 1977, would have made a comment like that. Now, and one of the reasons I say that is because, if I can quote, if you try to make a complaint against one of our members, and that's what makes me think that it was most likely another organisation that was complained to, despite the fact that AWA has said he's quite certain that it was the medical board, but he initially did think it was the AMA, and he changed his mind about that. And I think the referral to members and the sort of language that was used would be very unlikely to have come from the medical board. I think it's most likely another organisation.
And are there any records from the medical board from 1977 available to be able to search for?
None that we could find.
Could I ask that the statement of AWB, which is behind tab 4, please, be put on the screen, and at paragraph 33, starting at paragraph 33. Again, Professor AWB also states that he attempted to make contact with the medical board. At paragraph 34 there, he said, when I spoke to a person answering the phone of the medical board, I told them about my complaint of sexual abuse and named Dr. Rolleston. However, at the time I did not want to go on record and leave my name as I was concerned about protecting my mother. Now, in terms of the documentation that's been produced by the medical board in these proceedings, there's been no record of any telephone calls such as this. So can I first of all ask if such a phone call was made today where a person certainly named a doctor and yet didn't give their own name, would there be a paper trail of that?
There certainly should be, and there should have been then.
Okay. And in relation to assisting this caller, who is clearly still struggling in relation to knowing how to go about making a complaint, today, would the Medical Council be in a better position to make it easier for this potential complainant to make that complaint?
Yes, particularly if we knew the doctor, as was the case here. And even if the doctor had no other record, like Rolleston in fact did, that paper trail would and should have been done. And then what probably would happen now is that we would make further inquiries with the complainant. And if you can remember that when the two were put together, the two complaints of 2006 put together, there was a communication between the then medical board, lawyers and the complainants. And the same sort of thing would happen today, I'm quite sure.
Now, can I ask that the document of the statement of AWG behind tab 2 be put on the screen at paragraph 32. This is AWG, Professor, and just so you know, AWG is the person who made the complaint, who made the telephone call. There was a telephone call made in 1992 to the medical board, and there are handwritten pieces of paper where Dr. Rolleston's name is named and AWG's name is named. Now, AWG has given evidence that, in fact, it wasn't him that made that telephone call, and he's referred to in a number of places in the evidence as just the male caller. Now, at paragraph 32, AWG has said, on or around the 27th of November 2009, I received a letter from the HCCC informing me that the medical board had forwarded to them my complaint regarding my experiences with Dr. John Rolleston. As I mentioned previously, I had not contacted the medical board on any previous occasion, hence I did not understand what was meant in this letter. It was not explained to me what the HCCC's role was. I had not heard of or had any knowledge about the HCCC or the medical board prior to receiving this letter. So what it would seem from this evidence, Professor, is that somehow those pieces of paper that were at the medical board somehow got converted 17 years later into a complaint that the complainant heard about for the first time here. Can you shed any light on that?
No, I can't, but I think if that was indeed the case from those pieces of paper being put together 17 years later, it was quite an achievement.
I have no further questions, Your Honour and Commissioner.
Does anyone else have any questions?
Yes, Your Honour, just briefly.
Anyone else?
Yes, Your Honour.
Oh, yeah.
I do, Your Honour.
Right.
I've got two, Your Honour.
Well, you should go last, I think, Mr. McCulloch. Are you agreed as to who should go first?
Yes, Your Honour. Thank you. So my name is Aaron Kernaghan and I act for AWA. You've just been asked some questions about AWA. Can I ask that his statement be put up on the screen? I'll just ask you to refer to paragraph 78 of that document. It starts at the bottom of page 16 and continues to page 17. So
Paragraph 78.
You may have heard AWA give his evidence in this regard. That's in relation to a recent attempt made at the start of this year to make a report to your organisation. Did you remember that evidence?
Say it again.
Do you remember that evidence from AWA?
Yeah, I didn't hear the evidence. I've read the transcript.
In any event, he gave evidence of having
Yes.
initiated a process and is making complaint here and made the same complaint in his evidence that he hadn't up to that point received a response. Can you speak to why he wouldn't have received a response?
He has received a response, yes.
When did he receive a response?
I need to refer to my iPad if I may.
If it assists, Your Honour and my learned friend, I sought some instructions about this very matter and was going to lead some evidence from the witness in due course about it. To the extent that there's documentary material available, there may be an email or two. We can provide that in the next little while. It'll just save some time because as I apprehend my instructions, some steps have been taken not only to update the website in response to AWA's complaint that the email, though lost, was found and was eventually sent to him.
Yes, I was trying to get the exact dates and I just haven't been able to find it right away. But that what was just said is correct, is that he sent an email in, this is from memory, email in January for some reason that email was lost, and despite searching for it, wasn't found. But we managed to get the Health Practitioners Council's authority to get their IT people to go back in electronically and dig it out, which they successfully did, and that was, I think, in March. And there is record there of telephone calls to AWA telling, because he'd asked, the reason they went back in March, because he'd asked for a copy of the email and they found it, and also told him about the website being revised, and a complaint form in fact being put on that website.
And a copy of those emails can be provided to the Royal Commission.
They can, yes.
Thank you. Thank you, Your Honour. Thank you, Commissioner.
Professor, my name is Kumar and I am counsel for AWC, who's one of the survivors. Professor, you were asked a question by Dr. Bennett at page 14294.24, and that is where, Professor, you paraphrased the question. And if I could just read your paraphrasing of the question, it was that, if I can paraphrase your question to make sure I understand it correctly, an adult comes to a doctor and says that he has been sexually abused as a child. Does that doctor have an obligation to report to the Family and Community Services under the Child Protection Act, despite the fact that he's no longer a child and it is not a child, and it is not a child, but it is a class of children? If I could ask the question, Professor, if an adult comes to a doctor and complains that they have been sexually assaulted as a child by a doctor, does that doctor have an obligation to report the matter to either the medical board or the HCCC?
Yes, because in that answer to Dr. Bennett, we were talking about that specific Child Protection Act. However, I agree with your proposition, is that that doctor has an obligation, if not a legal obligation, but a moral obligation as a medical practitioner to report that to an appropriate authority.
Who is the appropriate authority?
The Healthcare Complaints Commission will be an appropriate authority, the Medical Council will be an appropriate authority, the Family and Community Services would probably be an appropriate authority, and the police would also be an appropriate authority.
In the case of Dr. Olliston, the board did not make any notification or referral of Dr. Olliston's conduct to police, did it?
No.
And the HCCC didn't make any notification or referral either, to your knowledge?
To my knowledge.
With the benefit of hindsight, do you think that the board or the council should have referred Dr. Olliston's conduct should have referred it to police?
Yes, with the proviso that the complainant would agree to that, because I think, as one of the police witnesses pointed out, there's an issue as to whether the complainant wants to go through that sort of thing with the police. So the answer to your question is yes, with that proviso.
Thank you, Professor. With the chaperone conditions that were placed on Dr. Olliston, there were two main conditions when his registration received conditions. Those conditions, as has been stated, were firstly that the doctor wasn't able to treat people between the ages of 11 to 18, and the second condition was that a chaperone be present while the doctor was treating children aged 0 to 10. In the case of AWF, AWF was 20 at the time of the last count of sexual abuse by Dr. Olliston. I'm not sure if you're aware of that fact.
I am,
aware of
yes,
that fact,
I am.
Professor? With that fact in mind, with the benefit of hindsight, do you think that the conditions were adequately imposed on Dr. Rolleston? That is, that he was able to treat people aged 19 and over without a chaperone?
I've turned my mind to that.
Your Honour, may I object to that, please? Because it really is asking the Professor to second guess what properly qualified members of the relevant committee decided at a particular point in time. And it can't assist the
I think it may not be of great significance, but the Professor can be asked his opinion, Mr. McCulloch.
As Your Honour, please.
Thank you, Professor.
I've turned my mind to that, bearing in mind that all the previous misdemeanours, no, not misdemeanours, activities, unlawful activities by Rolleston were on people under the age of 18, and we were talking about child sexual abuse, which is what this commission is about. I think it was reasonable to think that a person who is an adult came under a different category, and with not trying to second guess the Section 166 delegates, I think that's probably the way they thought, that this was a childhood issue, that over the age of 18 you're no longer a child, and you would have much more say in the matter than a vulnerable child would. However, if a person had come completely on its own, or even with this history, and complained that this had happened to a 20-year-old or a 25-year-old, then certainly the chaperone conditions would have been extended to that age. And that is something not very common in males, but that's something that we see quite frequently. Not frequently, I'm pleased to say. We see from time to time of females complaining about an action of a doctor, and we take that sort of action with them.
Professor, in considering the appropriateness of the chaperone conditions, do you think that a relevant factor would be that Dr. Rolleston was practising at Broken Hill, and that there may have been vulnerable patients who were aged 19 to 20?
Are there vulnerable patients aged 19 to 20 in Broken Hill? I think that the demographics of Broken Hill was probably a bit different from other places, but I couldn't guess how vulnerable people would be at that age in Broken Hill.
In terms of the chaperone conditions, were Dr. Rolleston's partners of his medical practice informed of the conditions, to your knowledge?
The usual thing is to do that, and it is usual, and I can't from memory be sure about this, is for there to be a sign in the practice saying chaperone conditions have been imposed.
Is that a practice whereby a notice is put in the practice?
Yes.
And as to the hospital, to your knowledge, is the hospital informed of the chaperone conditions as well?
Up until recently, the employer wasn't notified, but if the chaperone conditions applied to the hospital practice as well, then they would have to be notified.
So is it the case that the hospital was not informed of Dr. Rolleston's chaperone conditions?
I'd have to take notice of that question.
Is that you don't know the answer to that question?
I don't know the answer off the top of my head, but with sufficient notice, I could give you the answer.
Are there any records that have been produced by the board or the council that show that Dr. Rolleston kept his chaperone conditions?
there are records to show that he didn't.
But is there evidence to show that he complied with the directions before he didn't?
I don't understand the question.
There's reference to there being logs or records of supervision. Have those documents been produced to the Commission, to your knowledge?
As far as I know, they have been, but you'd have to correct me if I'm wrong.
Finally, two questions, Professor. The first one, could Dr Rolleston operate a private practice in a hospital in 1979? To your knowledge, was that a practice that could be done?
Could Dr Rolleston in any hospital
Specifically in the Royal North Shore Hospital?
That practice would vary from hospital to hospital, and you'd have to ask the North Shore people about that.
Is that a practice that could be done now?
There are certain classes of employees, namely staff specialists, that are allowed rights of private practice within the hospital. And I know that Dr Rolleston was employed in the emergency department of Royal North Shore, and the emergency staff specialists are excluded from private practice in the hospital.
Were they excluded in 1979 from private practice in a public hospital?
I can't be sure of that, but I think it's likely, but I can't be sure of that.
And finally, Doctor, in the period 1973 to 1984, in your opinion, was it considered good practice for a general practitioner to see or consult with a boy aged 12 to 15 on their own without a parent or guardian?
I think that happened quite frequently. And in fact, you said 1979 to...
1973 to 1984.
Okay. So in the latter part of those dates, adolescent medicine was becoming more of a specialty. And one of the things that adolescent medical specialists encouraged, and in fact almost insisted upon, was that the adolescent child, particularly the older one, should be seen alone by their doctor rather than with their parents, to give the adolescent a chance to vent their feelings and talk about things that they wouldn't necessarily talk about with their parents, and to give them a feeling of being in control of their own health.
Would you consider that to be good practice today?
Yes.
Thank you.
Your Honour, I said 2, but it's grown to 3 in the course of Ms Kumar's questioning. Professor, Dr Bennett asked you a question that began at the base of page 14280 and continued at the beginning of the next page, and it was a question about the need for medical boards to be mindful of the fact that on the one hand that you have the Healthcare Complaints Commission that are doing things in the way they do things, but in fact it's the medical board that has the power to do things immediately and act very quickly. And you answered about having lists and keeping track of things, but perhaps some better level of dialogue. I just want to ask you, arising from that answer, is it your understanding that if during its investigations the HCCC becomes aware of something that evokes concerns about a possible need for a Section 150 hearing to either put conditions on a medical practitioner's registration or to consider suspension, that the HCCC will provide a brief about that to the Medical Council for the Medical Council to determine whether to constitute a Section 150 hearing?
Yes, and that has happened.
Thank you. Dr Bennett asked you a question about when things were changing in relation to Rolleston's apparent compliance with imposed conditions, and made a suggestion that there was a time perhaps to review the situation by having a further Section 66 hearing. In relation to that line, does the national law now provide, pursuant to Section 150 capital C, an entitlement in the council to seek a review, and that review can include, because of subsection 2, a suspension if thought fit?
Yes.
Thank you. I'm trying to remember what I wanted to ask. You'll remember that Ms. Kumar asked you some questions about whether partners in a medical practice or personnel at a hospital would be put on notice about conditions pertaining to a medical practitioner's registration. Is it the current practice in a Section 150 hearing that a respondent medical practitioner is required to submit to the council a form where the medical practitioner provides every address at which they practice for the purpose of then the council notifying any determination made by the 150 delegates to those various addresses?
I can't answer that accurately, I'm afraid, because I don't know the answer to that, but it would seem a logical thing to do to me. But I, again, need to take notice of that question and consult with the Secretary of the Medical Council to see if, in fact, that is done.
Or perhaps just to cut through it a little bit, if His Honour and the other Royal Commissioner have in mind that that is a question based on recent professional experience, I'm just suggesting to you that that's a regular procedure and you're just not able to answer that on the run. Is that what you're saying?
Yes.
Well, nothing further.
Professor, could the Professor's statement be put up onto the screen, paragraph 155, which is, well, it doesn't have page numbers, I'm afraid. And of course, Professor, I'm your counsel appearing for the Medical Council in these proceedings. I just want to show you the portion of your statement at paragraph 154, when it comes up, which deals with the Section 66 proceedings taken in 2009. And I'd just like to direct your attention to the conditions as they appear, particularly D, E, F and G.
Yes.
Let me know when you've read those.
Yes.
And do they appear to you to be the standard form of conditions, or at least some of them, which apply when chaperone orders are made?
That's correct, yes.
And the one at F, paragraph 154F, in fact requires Dr. Rolleston to notify any other practitioner, including people who may work at the site where he will be working, of the conditions, and to forward to the council within 7 days a copy of the conditions signed by those practitioners. You see that?
That's a fairly standard condition, yes.
When you mentioned in your evidence the question of signs being put up in the practice, was this the condition you had in mind or something in addition to this?
It is now common practice for a sign, when a chaperone condition is put on a practitioner, that a sign is put up in the consulting room about that, so that not only the other doctors working there know, but they'd know because of Section F, but also the patients would know that when they go in, they're going to have a chaperone with them.
Thank you. May I next ask you a question or two about what were Section 66 and now Section 150 proceedings, and several of the, or at least two of the victims, have observed with some concern of a period of only 8 weeks suspension. Are you able to tell the Commission how that period of 8 weeks comes about?
That was in the previous Medical Practice Act.
Yes.
And the situation is that the maximum suspension time was 8 weeks, and it was almost universal practice that after that 8 weeks, I think I probably used the term almost as incorrectly, it was universal practice, that after that 8 weeks, an application was made to the Chief Judge of the District Court, or before the 8 weeks had expired, in fact, to the Chief Judge of the District Court to extend the period of suspension for another 8 weeks, and that would roll on until a decision was made as to what action would be taken. So in effect, although that doesn't happen now with the national law, in effect, when a doctor was suspended for 8 weeks, he was suspended until the decision was made what sort of prosecution, if any, was to be made. It was a rolling on sort of procedure.
So there might be several.
Often several 8 weeks, yes.
And indeed, such a determination was made in respect of Rollison on the 25th of March 2010, and as your statement explains, it was one example of where it was rolled forward.
Yes.
The next thing I wanted to ask you about was the period of 4 years when an order for suspension or cancellation is made, during which time the practitioner may not apply for re-registration.
Yes.
First, as to that, we've heard in earlier evidence that those proceedings, if such an application is made by the practitioner after the 4-year period has expired, are taken before the tribunal. And in that case, does the board or now the council have a role to play in those proceedings?
Yes, the council very frequently will oppose re-registration and appear in the tribunal. We represented the tribunal opposing any re-registration. If you take the case of Rolleston, if, as the question was asked this morning, if he changed his mind despite his statutory declaration and applied for re-registration, the Medical Council would vigorously oppose that re-registration for good reason. And that has been the case in many other cases. A recent case, a doctor has been suspended for 10 years and he has applied for re-registration. We opposed it vigorously and the tribunal agreed with our opposition. So it's something that happens not infrequently. And as I said, in Rolleston's case, if he did apply for re-registration, we would vigorously oppose that.
Next, on the subject of the website and the inquiry and complaint suggestion made by victim AWA, have you made inquiries to determine whether any changes which have been made to the website have been made following on from his contact with the council?
Yes, I have.
What changes have been made?
And in fact, one of the major complaints that he made was that there was no form to fill in. You make a complaint, but there was no electronic way of doing it from the council's point of view. There was from the healthcare complaints point of view, but from the council's point of view, there wasn't. We became aware of that, and in fact, soon after we became aware of it, we put the form up on the website, and it's presently there.
And as president of the council, at least until the end of next month, are you able to inform the Commission of the council's attitude to such suggestions as they may be made in the future?
I think that not only applying to the website, but to all things, that continuous quality improvement is something that everybody should be engaged in, and that's a good example of that.
May I next ask you about the question of doctor education? In one of your answers, you indicated that much of it is dependent upon the doctor in question, or the 27,000 odd doctors in this state, reading the literature which is forwarded to them through email or post, however it be done. In addition to that literature, is there a system of compulsory practice development which has to be undertaken annually by medical practitioners?
Yes, that's a requirement for registration through the Medical Board of Australia.
And is it organised into a number of streams, for example, one dealing with ethics and one dealing with particular medical procedures, or is it maybe accumulated in any fashion?
What we call CPD, Continual Practice Development, is run by the various specialty colleges, and the specialty colleges are accredited by the Australian Medical Council, and part of that accreditation is their CPD program. And it depends on the college's actual CPD program, but at the latest iteration is the sort of, we don't call it ethics, we call it professionalism, is part of the CPD requirements from the AMC.
So that if the Commission was so minded to make a recommendation that there be a particular strand set up as part of annual continuing practice development, which took into account the concerns of this Commission, is that something which, as you understand as the current President of the Council would be prepared to embrace and implement?
We'd certainly support that.
They're all the questions I have.
Yes. Dr. Bennett, any questions? Thank you, Professor. Thank you for your evidence. You're formally excused.
Thank you.
Your Honour, that's the witness list for the day. There are no further...
And where do we go on Monday morning?
Monday morning, we're on the 6th day of Part 1, and we have, we'll hear from Mr Kirkpatrick, who suffered childhood sexual abuse in the late 60s at Royal North Shore Hospital. We'll hear from Associate Professor Vicky Taylor, who is the Chief Executive of the local health district, and we'll also hear from Dr Mary Foley, and she is the Director of New South Wales Ministry of Health.
And Tuesday?
Tuesday, we're keeping in touch with the legal team and AWI from Victoria. I'm anticipating that is part 3 of this case study, and it's anticipated it will take 2 days. When this case study started, we were thinking it was going to be on Thursday and Friday for those 2 days. As this week has panned out so efficiently, we're anticipating that we'll bring them forward. I'm just instructed that summonses have been served on the former commissioners of the Healthcare Complaints Commission, and we anticipate hearing from them on Tuesday morning or Tuesday.
Is it proposed that they'll make statements or that they'll just give evidence orally?
At this point, I understand they'll be giving evidence orally.
Right. Is everyone else aware of that?
No, Your Honour.
Now
No, I wasn't here. Well, I'm just instructed at this moment that these
Well, I think
summonses
you've got to
have been
speak to
served.
Dr Bennett about that, but I signed summonses this morning for those two people to come and give evidence. Their evidence obviously will be an account, if you like, of the actions or lack of actions of the Commission during their time as Commissioners. But I formed the view it was appropriate, having regard to the facts that had emerged, that they be asked to come and give evidence about their time. So everyone should understand that, and that'll be Tuesday.
Yes, Your Honour. So we're anticipating on Monday we will get through those 3 witnesses and we'll have that contained then. Tuesday at the moment, I mean, first thing Tuesday morning, the 2 commissioners should be available. I can't predict how long we'll be. Victoria probably will be told to be available on Tuesday, potentially Tuesday afternoon, but certainly the commissioners will be available. I'm not anticipating having any formal written statements. They will be provided with a limited set of materials to have had regard to, and that will give them time to look at it, so as we can ask them to give an explanation.
Yeah. Mr Hunt?
Your Honour, could I say 2 things? One on the general scheduling. My client does not seek to appear and would seek leave to be excused in relation to Part 2 and Part 3 of this case study.
That's entirely appropriate.
And if I could just indicate that neither Mr Cone, Ms McLaughlin nor myself anticipate acting for either of the former commissioners, although we would obviously, or some of us would obviously attend on Tuesday to participate in the continuation of Part 1 of the case study.
Yes, well, we'll see what unfolds there.
Thank you.
Anything else, Dr Bennett?
No, there are no procedural issues.
Very well. 10 o'clock on Monday morning.
All stands.